So here's some facts about your privacy that might surprise you. Under Australian law, you have the right not to use your real identity online. You also have the right to access all your personal data collected by companies and governments, the right to know what they're doing with it and if it's being shared with others here or overseas. So that's the law. Now to what actually happens. Today, the Australian Privacy Commissioner Timothy Pilgrim ordered Telstra to release 12 months of metadata to a Fairfax journalist after a nearly 2-year battle. Telstra argued that the information wasn't personal, and it's confirmed it will appeal the decision. The Commissioner has also revealed that more than half of the 20 companies audited recently by his office are not complying fully with legal requirements around privacy rights. Even so, Mr Pilgrim says things are improving.
The good news is that all 20 websites at least had a privacy policy, which was easy to find on their website.
In a moment, the Privacy Commissioner will join us here in the studio, but first, Margot O'Neill prepared this report about just how tough it is to work out what's happening with our personal data.
This is some of my metadata, and what you can see here is the cell phone tower that I was connected to, the location.
Fairfax journalist Ben Grubb decided 2 years ago to exercise his legal right to see his personal metadata collected by Telstra. At the time, there was debate about how police and spy agencies were scooping up that kind of information.
I thought, what is this metadata? Why do the law enforcement agencies want it? And why can't I have it?
It didn't go well with Telstra.
They said no. They didn't want me to have access to it. They said that it wasn't personal information and that it didn't necessarily have anything to do with me.
Metadata doesn't show the content of your emails or phone calls or web searches, but it shows when, where, what, to who and for how long. If someone has your metadata, they pretty much know your life.
So what you can see here is what a German politician did with his metadata when he successfully sued his telco. And you can see pretty much his entire life in how his mobile phone mapped him.
It provides practical
Today, the Privacy Commissioner formally determined that metadata is personal and Telstra must hand it over.
So this is a landmark decision. There's never been a ruling like this before. And I know that companies like Telstra believe that this is going to have big ramifications for their business.
But Telstra announced this afternoon it would appeal, saying the decision would require us to go well beyond the lawful assistance we provide to law enforcement agencies and the government's data retention regime, and would have broad implications for the Australian economy and the development of new technologies. There's a seismic global shift going on over what constitutes individual privacy and how much control you have over your personal data. And it really matters.
We have a bunch of things on the table here. One is data aggregation. Another is then using the data to make predictions about the future. Both are done all the time. I mean, they are done millions of times a day. They are done dozens of times a day about every person. Like, we predict you're a terrorist, and so we don't let you board an airplane. Or we predict that you're likely to commit fraud or commit a crime in the future, so maybe we don't let you have a job that requires a security clearance.
Mr. Rabbit, wait!
So how can you track it all down? Luckily, most companies have privacy policies to let us know what's what. You've probably never read one, right? But here's some of the interesting things we found when we did. Origin Energy is Australia's largest energy retailer and was recently audited by the Privacy Commissioner. Customers hand over sensitive information like bank and credit card details and credit history. Its policy says that personal and credit-related information may be held in 11 different countries, including Vietnam, China, Chile, Botswana, Indonesia and Papua New Guinea. Origin says it takes reasonable steps to ensure information is handled according to Australian law, and it says the Privacy Commissioner found no fault with its policy. International data transfer is increasingly common. Some companies share personal data for marketing purposes, like with call centres.
you should definitely be concerned. 2 large corporations in the US which were using call centres in Mexico and the Philippines. Unfortunately, the employees in those call centres were happily selling people's credit card details.
Online classified ad giant Gumtree.com.au says it collects information including, but not limited to, device ID, device type, geolocation information, name, email, address, phone, financial information, social media and demographic data. Gumtree's policy says that it will not disclose your personal information to third parties for their marketing purposes without your explicit consent, except for companies in the eBay group, which owns Gumtree and which has its own privacy policy. Okay, there's quite a lot of companies in the eBay group.
Brady dances, throws, and it will be caught.
Let's try the eBay subsidiary, StubHub. StubHub is one of the world's largest live entertainment ticket markets. Its privacy policy says it may share some of your information with co-brand partners. And there's more than 100 of them.
Goodbye, Dinah. Goodbye.
I think realistically, if you really tried to follow who each policy lets you share with, and you went, say, through 5 generations of that, I think you might be in the tens of thousands of types of companies or locations around the world in which the data might be found.
As technology continues to race ahead of regulation, many experts believe Australia's privacy enforcement is woefully under-resourced and needs far broader powers. So if I am stalked by someone on social media, can I go to the Privacy Commissioner about that?
Not at all.
Who do I go to?
Nobody. There are mechanisms where you can bring in policing, but in terms of me taking your data as one individual against another individual, there's no extra protection.
In the hands of the individual, at the moment in Australia, your privacy rights, such as they are pretty well unenforceable.
So what about all these privacy policies we don't read and all the consent buttons we click?
Here's the way I would summarise most privacy policies. We're going to collect as much information about you as we can, in any way that we can. We're going to keep it forever. We're going to use it for any purpose, and we're going to sell it to anybody who'll pay for it.
So I think the evidence shows that privacy policies are pretty much useless. There was a recent research study in the United States showing if you just read the privacy policies of the top 100 websites that most people visit, it would take over 30 days a year just to stay up on those. It was the US government, it was the President's Council of Advisors on Science and Technology who issued a report in May of 2014 on big data, in which they said only in some fantasy world do people believe that notice and consent are appropriate foundations for privacy. I agree.
And the Privacy Commissioner, Timothy Pilgrim, joined me here in the studio just a little earlier. Timothy Pilgrim, welcome to Lateline.
It's good to be here.
Now, more than half of all the major Australian companies audited failed to comply with privacy rules. What consequences do they face as a result of that?
Well, at this point, we've undertaken assessment of those organisations. The aim is to help educate them to improve their privacy policies. It's only been 12 months since the new York laws came into place, and what we want to do is give them some guidance, and hopefully they will improve their policies, and in another 12 months we'll go back and have a look at how they've improved them.
When we talk about the digital space, what exactly is considered private and personal in a legal sense?
Well, personal information basically is any information that can identify an individual or from which an individual can be easily identifiable. So there is a vast amount of information in the technological sphere now, which when it can be brought together, can actually identify us in ways in the past it was never able to. And we see that quite often now in the broad debate around issues such as metadata.
So, speaking of metadata, in the case of Fairfax journalist Ben Grubb, Telstra says it will appeal your decision because, in their words, having to disclose a journalist's metadata to them would, quote, have broad implications for the Australian economy. How significant is this case?
Well, from my perspective, the issue we had before us was that this individual wanted to seek their personal information held by Telstra. Now, people have a right under the Privacy Act to see their personal information and get access to it. The question here was that the information was being described broadly as metadata, and the decision came down to what bits of information were actually going to form personal information. So which bits of this information Telstra held could identify this particular individual. And my decision was that the information that was being sought did constitute personal information and should be handed over to him.
In your view, as the Privacy Commissioner, how significant is metadata in terms of privacy and trying to maintain some level of, personal secrecy around certain things?
Well, I think the whole issue of data and information about us is getting very complex for all of us in the community. And I do get a bit worried when there's terms like metadata are used often, because I think what we're going to see in years to come is that the information which some people would now lump under the definition of metadata is going to broaden significantly. So what we focus on is what bits of that information is personal information, how's it going to identify the individual, and the individual should then have rights to be able to access it.
Privacy policies are around 3,400 words. How many people would ever read those?
Well, we did a survey recently in 2013, and we found that just over 50% of people were saying that they were reading privacy policies. Now, this is clearly not enough because they're an important document that we all should take time to read, because at the end of the day, they're going to tell us where our information is going. So we'd like to see that number improved. And a way of improving it would be to get the companies to actually shorten their policies and put up front the most important information a person needs to know. So we want to work with organisations to make sure that they get those policies right so that they're useful for people and easily accessible.
But just telling someone that you're going to disseminate their information to, in the case of Origin Energy, we hear in Margot O'Neill's story that it went off to 11 different countries, and this is personal information and credit-related information even. The mere fact of the company telling us that doesn't necessarily provide us much comfort.
Well, it doesn't necessarily provide comfort to everybody. What it does do is tell you where the information is going, and you may want to think twice if you want to deal with a particular company. We found that 60% of Australians have actually made a conscious decision not to deal with an organisation because they didn't like the way that they were going to handle their personal information. But in terms of information going overseas, one thing that's important to remember is that at the end of the day, if an Australian company sends information overseas, it will remain accountable for what happens to it, and if something goes wrong, they will be accountable at the end of the day.
Do we need law reform in this area so that perhaps your office doesn't necessarily appear quite as much of a toothless tiger as perhaps some people might think it is?
Well, I certainly don't think we're a toothless tiger. We do have quite a number of powers that are there for us to use to resolve complaints. And we've just been through a long law reform process. And the result of that law reform process was actually to give me more powers to be able to resolve and remedy complaints from individuals and large systemic investigations that I undertake. So I think we need, just after 12 months, to watch these work a bit longer before we go to looking at doing any more reform.
So I guess you wouldn't necessarily agree with US cybersecurity expert Fred Kate, who describes privacy law as a, quote, fantasy world, and that we're perhaps better to just give up any notion of privacy online.
No, I certainly don't agree with that. I think that there are responsibilities out there for organisations to comply with the law we have, and people have a right of recourse. And at the end of the day, we have one of the most powerful tools to us, which is to say, I'm not going to deal with that organisation because I don't like what they're going to do with my personal information.
Timothy Pilgrim, thank you very much.
You're welcome.
That's all for tonight. You can find tonight's interviews and stories on our website. I'll see you again tomorrow. Good night.